in my question number 4 today on the unilateral conversion. As we know, it's a very hot topic now, sensational topic in the country. The minister who replied my question today, whether the government was serious in addressing the issue of unilateral conversion, was given a very, very flimsy, disappointing answer by Law Minister, the Prime Minister's Department, Yang Berhormat Nancy Shukri. What had been asked was whether or not, a few questions, whether or not there will be amendments to Section 51A of the Law Reform, Marriage and Divorce Act 1976. However, what Nancy Shukri mentioned was something that you and I could have just Googled and read from any news portal in the country. She didn't give a solid answer. In fact, up to now, we are coming to the third day of the Parliament sitting for the first sitting of the year. There has been no draft of the amendments to the Section 51, the law reform, Section 51 of the Law Reform, Marriage and Divorce Act 1976. No such bills, no such proposals, nothing mentioned. Only mentioned in the order paper on the first day of the sitting. Now, in 2009, there was a cabinet decision that prohibits unilateral conversion of minors, children below the age of 18, by any single parent. So it's been 7 years and we have not seen any changes, any reforms. Now, why is it that in a case like this, that after 7 years they're dragging their feet, but we have seen in the past decisions made by the cabinet executed immediately in the coming parliament sitting. No chance at all for any debate, no chance of a discussion, no chance of a public consultation. But in something so critical like unilateral conversion, you find that something like this has been the government has been dragging their feet on this matter. In February 18, as you can see in the Malaysian Insider, there's one news here. Nazri promises law reforms for interfaith custody cases. So when you find that the current tourism minister, ex-law minister of the country, making a statement like this, and the current law minister, Nancy Shukri, saying it is in process, we are studying it, it will be brought, it will be drafted, it will be tabled. So you find two ministers of the same cabinet having contradicting statements and stand on unilateral conversion. And for the Prime Minister, I think the Prime Minister should take a stern stand on it as the head of state for the country. Because this issue doesn't just affect Indira Gandhi or Deepa. There should be no more Indira Gandhi or Deepas in this country. And how many more Indira Gandhi and Deepas that we had before and the cases have been just swept under the carpet. So we ask that the government takes this issue seriously. No, don't treat it like it's one of those flimsy issues that you can just drag your feet on, because it affects the livelihood, the welfare of the child. And as we have seen in the cases of Deepa and Indira Gandhi, both children are separated from their mothers. Where is justice there? The issue is not religion only. The issue is justice. And we have seen that justice has not been served in this case. And disappointing parliamentary answers. Disappointing. Nothing concrete, nothing solid. Even you have seen it. She didn't give me any, she didn't answer my question. And the so-called committee consisting of ministers, what have they done? They have shown that they also are not committed. Everyone is just pleasing each other. Oh, we will try. Oh, we will do it. Nothing concrete, nothing serious. Now, how long is this going to drag on?
Okay, good morning. As my colleague has said, the question that was asked today was what laws will the government change or put into amendment to solve these inter-custody, interfaith battles, right? The minister today had in total answered not only Kasthuri's question, but 10 other MPs' questions, including my own. My question was whether the government has plans to amend Article 1211A of the Federal Constitution. So the minister, unfortunately, in a very short few minutes, answered 10 MPs' questions, and we were not given time to ask further questions because this is an issue that is of national importance, and the country is watching closely. As Kasthuri has mentioned, the cabinet had promised in 2009 to solve this problem, but it has not been solved. And a special ministers committee had been set up after the Indira Gandhi case to say that they will look into it, to amend the laws and to solve this problem. but yet it has not been solved. Nazri has on the 18th of February said that wait for Parliament to convene. In his own words, he said several laws will be amended in the coming Dewan Rakyat sitting to ensure the rights of the people are preserved in the matter of inter-custody battles, and some laws will be amended this sitting. So we have, it's already been the third day, there are no bills in Parliament concerning this issue. The minister herself said at the moment no laws are being planned, to be tabled this Parliament sitting to solve this problem. Now, even I myself was not allowed to ask further questions, regrettably and unfortunately, because the specific question that I wanted to ask was this, on Article 1211A. Now, it has long been argued that amending the Law Reform Marriage and Divorce Act alone will not solve the interfaith custody battles. Now, the reason for this is we have to go back to the root problem, which is the jurisdiction of the civil courts to hear this matter. In the Indira Gandhi's case, the Court of Appeal held that the civil courts had no jurisdiction to hear the matter, and only the Sharia courts have the right to hear this matter because of Article 1211A, which says that the civil courts have no jurisdiction over matters coming within the jurisdiction of the Sharia court, right? And this has created a confusion in the Malaysian judiciary, Malaysian legal system. This Article 1211A was introduced in 1988, and until today, we have seen this battle between the civil courts and the Sharia courts. We have seen cases where where one spouse is a non-Muslim, getting a court, basically, and one is a Muslim, converts herself, goes to Sharia court, and gets a custody order of a child, right, of a non-Muslim. We have seen religious authorities enforcing or using the police to enforce a Sharia court order on a non-Muslim. We have also seen that the AG has refused to enforce court orders, right, issued by the High Court. Right, so these are serious problems, all starting from Article 1211A as well as Article 121(1). Now, in 1988, the government then amended Article 121(1). Let me just briefly explain. In the original Article 1211, it says that the judicial powers are vested in the High Courts of Malaysia. Now, this is an important non-negotiable. You cannot just take it out because it guarantees the separation of powers between the judiciary, the legislative, and the executive. Now, the word judicial powers vested in the High Court was taken out. And what has happened after that was that the judiciary then became subservient to the Parliament. So High Courts could only interpret laws that were passed by Parliament and not to the Constitution, because the Constitution is supreme. And at the same time, when they amended 1211, they also amended 1211A. So these are things that the government must look at to clear up the confusion as to the jurisdictions between the Sharia court and the civil courts. And unfortunately today, we see that there is no political will on the government to act to resolve this issue. Thank you. Any questions?
I'd just like to add that if in 2009 the decision by the cabinet had been followed through strictly as how they do with other controversial bills and acts, then we would not be witnessing Indira Gandhi and S. Dipa going through such excruciating pain. It is now the fault of the government because they drag their feet in this. I mean, the more controversial a bill or an act or an amendment to it, the faster it is bulldozed in Parliament. I mean, we have all seen MPs sitting up to 3 a.m., 4 a.m., debating the National Security Bill, etc., etc. Pota, Poka, you name it, Sosma. But something so critical like this has just been forgotten and just shelved for 7 years. Now, if they had acted promptly on it, the government had just like what Saudara Dwi had said, if they had political will, they would have addressed the issue immediately, instantly, so that there will be no cases of Indira Gandhi or S. Dipa now. So the what the mothers are going through now is a direct result of the government's negligence in protecting the welfare and upholding the rule of law in this country. And just now, a supplementary question was asked by a BN member of Parliament, and he asked whether or not this issue of unilateral conversion had been politicized. And I stood up and I said, let's start with the IGP to prevent issues like this to be politicized. Let's start with the IGP, because as we all know, a court direction was given for the IGP to detect the father, the husband of Indira Gandhi. But up to now, it's ding-donging all over the place. We don't know where he is. But for cases like Khalid Samad and Mat Sabu, they can turn up in front of their houses and arrest them at 3 in the morning and get Mat Sabu when he's sitting and having supper in a restaurant. But you cannot find the husband of Indira Gandhi. I find it just ludicrous to believe. And so we appeal and we ask, that the government does not politicize this matter. Don't play politics as far as the welfare of children is concerned in unilateral conditions. Be neutral, be just, and uphold the law.
Thanks.
I'll just read out my statement. Any question you can ask later. I've at the end of my debate